5th. And right now, very happy to welcome back our friend Elie Mystal, lawyer, justice correspondent for The Nation, author of the New York Times bestselling book, Allow Me to Retort, and new podcast, Contempt of Court with Elie Mystal. Elie, you're a one-man media empire here. You are the Howard Stern of legal media stuff.
Well, as they say in Sopranos during football season, this is my busy month, right?
This is your busy month. It is. Hey, look, I was just cramming, felt like I was cramming for an exam because I was researching while we were waiting to bring you back on. Look, I'm going to go out of order and start with the legal issue here about expanding the Supreme Court, contracting it, term limits, and the constitutionality of that. And I was just reading an article, fact checking here, an interview with a bunch of legal experts who said, well, with the good behavior clause of the Constitution, which says that judges get appointed their job for Article 3, Section 1 says judges shall remain in their position so as long as they follow good behavior. But the argument is there. You cannot have now term limits on the justices that are there. It can only be in the future. Well, what do you think about that?
Yeah, I think that argument is right. I think that term limits it's funny because term limits are the most popular court reform by far. Mm-hmm. And they're also the least constitutional. I think that's the best way of putting it, right? Like I can think of a way to make it constitutional. It's without getting the legal weeds. It says that they have to serve while in good behavior. It doesn't say where they have to serve. And so you can imagine a system where after 18 years, instead of continuing to serve on the Supreme Court, they are by law required to then serve on one of the lower circuit court of appeals. That shouldn't trigger the constitutional good behavior clause. So I like that argument. My problem is that to make that argument work, I got to go convince John Roberts and his 5 conservative friends, right? And like, who wants to be the guy? I mean, maybe Neil Katyal wants to take this one up, right? But who wants to be the guy to walk into John Roberts' courtroom and say like, actually, you have to retire this year, as well as all like 4 of your friends. Y'all have to go this year. Like, who wants to make that argument? Who thinks that argument is going to win? So
right. Do you also add to that? Do you also add like, and you got to leave your robe? Okay,
right.
So you can't take the robe. I'm sorry.
The way that these people work, it's more like you got to leave your crown, right? Right. And that's the problem with term limits. Like, I think there are good arguments to work around the Constitution, but the Supreme Court, as currently constituted, gets to decide what the Constitution allows and doesn't allow. And it's very hard for me to see how you can make term limits acceptable to the 9 people that would be affected by them in this climate, right? And so that's why I prefer other options, which I know people think that, you know, court expansion or jurisdiction stripping or whatever is more radical, but those options are the constitutional options. As I say in my podcast that you just mentioned, court expansion is the constitutionally preferred method of changing the Supreme Court. And that's hard for people to understand and hear, but it's the truth.
It's interesting. You know, I don't know if you ever looked into this at all, but in John Adams, he's lame duck, he loses to Jefferson, and the Federalists still control Congress, and they reduced the Supreme Court from 6 to 5. How did they reduce it to 5? Then Jefferson then expands it again to 6. And later we have 10, and then it's reduced down to 9. How did they do the reducing part and still be constitutional is my question.
I have, in fact, looked into this, Dean.
Elie's perfect. Tell me, Elie.
And the answer is that they didn't kick a member off the court. They said that when the next person retires or dies naturally, that position will not be filled because we have reduced it to 5 or to 9, depending on which president we're talking about, right? So Adams's whole plan was to, basically there was a judge that was like sick. And the reason why Adams went from 6 to 5 is that he didn't want Jefferson to be able to replace that judge when that judge inevitably died. When that judge inevitably died, Jefferson was like, you know what? We're going back to 6. Who cares, right? And then let's not forget, on Jefferson's way out the door, Jefferson was like, in fact, we're going to expand it to 7. So Jefferson actually expanded the court twice, once on the way in to go from 5 to 6, and then once on the way out to go from 6 to 7. So Jefferson got kind of 2 appointments, 2 extra Supreme Court appointments that John Adams really didn't want him to have because of partisan politics.
You know, it's so amazing when you talk about our history in this country that people don't know much, because you'll have people on the right going, no, the framers wanted 9 justices. Don't you understand? Like, no, you're an idiot. Like, you have those. That's like an argument Ted Cruz, who knows better, but would say, because the base would be like, it's your ruining tradition. No, the John Adams, who was a framer, who was the first vice president and the second president, contracted the Supreme Court for political reasons. And Jefferson, the next president, expanded for political reasons. The framers are all about expansion and contraction of the Supreme Court for political reasons. Yeah, that's the truth.
And not just them, right? So, like, first of all, you got to remember that, like, the founders said that there should only be 6 justices, right? That's what we started with at the founding. And the other thing is that none of the founders thought that the Supreme Court would be all that important. They would be, if you put one of these people today, here today, I mean, the first thing they would say is like, you let your Negroes talk on the radio. That is like, that's right. And then the second thing they say is be like, what is that in the air? You'd be like, it's a plane. And they're like, right. But the third thing they'd say is, are you kidding me? You've let these 9 unelected, unaccountable judges decide what laws you have? Are you kidding me? Because the founders thought that the Supreme Court would be, and I'm quoting Alexander Hamilton here, the least dangerous branch of government because it has neither the power of the purse nor the power of the sword. That means that it can't raise taxes and it doesn't have an army. So that the founders thought that the Supreme Court would always be subservient to the other 2 elected branches of government. Obviously, it hasn't turned out that way. And because it hasn't turned out that way, like you say, presidents have messed with the number of justices all the time. Andrew Jackson, I think, is one of the least understood examples. But like, Andrew Jackson hated the national bank. And the Supreme Court was like, we're going to have a national bank. And Andrew Jackson was like, we're going to put 2 more justices on the Supreme Court. That's the first time that we got to 9. We were at 7 from Jefferson, and Jackson put it to 9 because he wanted 2 extra people to vote down the national bank. And it worked. Lincoln was facing basically a Confederate Supreme Court, and he was just like, well, we're not going to have that. So in addition to not actually listening to the Supreme Court, which is something, people might want to talk about, Lincoln also added a justice to the Supreme Court and went from 9 to 10. FDR, that's the most famous example, right? FDR allegedly tried to pack the court, tried to put 6 justices on the court to go from 9 to 6 to 15, and he quote unquote failed. But did he really? Because remember, the reason why FDR wanted to pack the court was because all of his New Deal programs were failing in front of the Supreme Court. Then he starts threatening to pack the court. Then, magically, miraculously, who can say for why? One of the justices, a man named Owen Roberts, no relation to John Roberts, our current Chief Justice, changed his mind. And all of a sudden, FDR started winning the New Deal cases that he was losing before he threatened court packing. So, okay, court packing didn't quote unquote work, but FDR got what he wanted, didn't he? And I've said before, I would love to be a failed court reformer in the mold of FDR, right? Like, if that's what failure looks like, sign me the hell up. Because fundamentally, the laws and rules that FDR wanted to be passed through Congress, signed by him, that the Supreme Court was knocking down, the Supreme Court stopped that mess once FDR got serious about court packing.
I'm talking about Elie Mystal. And that's such a great point about the threat of court packing having the impact of what FDR really wanted. So what do you want to see done? I mean, is it expansion of the court? Is it a package of reforms, including laws that have ethics rules in it for the Supreme Court? What do you think? What do you want?
Yes, all of it. I want all of it. I want all of the reforms.
Like, it's like Willy Wonka. I want it now, Daddy.
Right?
Like, you're a Veruca Salt. So tell us.
I want court expansion for 2 reasons. One, because it's the quickest way to fix what's gone wrong with the court. It's the quickest way to address the fact that Mitch McConnell stole a seat from Barack Obama and then put Amy Coney Barrett on the court after the election to replace Donald Trump had already started. It's just the simplest way to redress that partisan error. But I also think that a greatly expanded court, and Dean, as you know, I think the current plan in Congress is plus 4 justices. I support a plan that is plus 20 justices. And I know that sounds like a lot, but the reason why I support that many is that I believe that more people would have a moderating influence on the Supreme Court, just because if you had a 29-person court, it's a lot harder to get 15 people to agree than it is to get 5 people to agree.
Can I just say for a second why I like that so much, whatever it might be? Adding 4 just gives us an advantage, but it doesn't bring legitimacy to the court, which right now the court is the lowest approval in terms of trust. And it's the widest gap, partisan gap, in terms of Democrats versus Republicans. But even among the average American, there was just 2 weeks ago, Quinnipiac, only 30% of Americans approve the job the Supreme Court is doing, the lowest in the history of Quinnipiac. And my thing to callers, what I put out earlier was, one was, what do you want to see as a Democrat? But I'm also intrigued about, because I believe deeply we need to increase confidence in the court in the bigger sense. If you want to live in a democratic republic, if you don't want to just start over, you got to increase legitimacy, and adding like 10 more might be that, because it's not just 4 is just purely partisan, and I'm down with it, but big picture, not the right move.
4 is fine for retribution's sake, but 20 is an actual reform. And look, Dean, I've talked about this. I believe in adding 20 so often, so completely, in terms of how it would reform how the court works, that I'd be willing to share. I'm not saying that we should add 20 and make them all 20 liberal, fire-breathing people like me. Let's add 20 and we can share. We can share 11 and 9. Democrats get 11, Republicans get 9. Because what he did with Merrick Garland cannot be accepted. Like, there is, like, I'm not a sap. Like, what McConnell did with Garland can't be allowed to work. But you want to do that. If Republicans want to give me votes, I will split the court that way. And if you did that, Republicans would still have a majority. Like, I would actually, if you add 20 justices and you split them, Republicans could still have a 15-14 majority on the Supreme Court. And I would be okay with that in the context of a much larger court with more moderate decisions, hearing cases in panels. The point of a panel is, and Dean, you know this, but a lot of your listeners don't, most lower courts, they hear the case in 3-judge panels, not as a full circuit. And those 3 judges are chosen at random. Just think of it this way. Wouldn't it be great if the next time Harlan Crow or Paul Singer had a issue in front of the Supreme Court, they didn't know which 3 justices would actually hear their case? Just think of how many more people they'd have to buy in order to guarantee an outcome that they liked, right? Like, it would be a lot easier to, it would look a lot better if the people who litigants in front of the court didn't know which judges they were getting. And that's something that you can do with a 29-person court that hears cases in 3-judge panels.
So you envision a Supreme Court like a bench, literally like a bench, like a baseball or football team, whatever, of Supreme Court justices, but they don't all hear every case. So from that 20 something, it would be randomly, let's say 6, 9, whatever the number might be.
Yep.
You've given us a lot of thought. I like this very much.
And look, it's not, I like to say because I'm very smart. No, I just look at what the other courts do. These numbers, I'm not pulling out of the back of my backside. All right. Everything that I've talked about so far is exactly how the Ninth Circuit Court of Appeals works, which covers California, Washington, Oregon, Idaho, and Hawaii, right? Arizona too, I think. The Ninth Circuit Court of Appeals has 29 judges. They hear cases in 3-judge panels, right? So like, this would not be new, right? And once you have that kind of system, now we can get into a world where we can start really talking about term limits and that kind of thing, because one of the things that, again, all of the lower courts do that is totally constitutional, because remember, the you have to stay on the court as long as you're in good behavior, that doesn't just apply to the Supreme Court, that's all federal judges. And yet the lower courts all have something called senior status. Basically, once you're over, I think it's 65 and have served at least 18 years or something like that, on your bench, you are eligible to take senior status, which means you can still hear cases, you can be part of the 3-judge panel, but your seat essentially opens up for the governor or whatever, or the president to appoint your replacement. And you have kind of a limited caseload, which is kind of appropriate, for a 65-year-old jurist, right? So if you had a greatly expanded court, what you could also institute is this senior status, where where you wouldn't kick them off the court, but they wouldn't be part of the en banc, the full circuit sits down and listens to a case, but they could still hear, some 3-judge panel cases. They could still hear, the occasional death penalty appeal. It would make the court able to do more business, quite frankly. But the seat would open up for the next president to appoint the replacement. Again, that's not an idea that I invented. That's how it works on every other circuit court of appeals in the country.
It's also remarkable that, Elie, we're having this discussion and you are still trying to be fair. And I am still trying to find a way to give legitimacy to the court because I believe in the system. While Republicans are ecstatic with tyranny of the minority, they're like, we got it. We represent 40 million less people in the Senate, but they were equal, even in terms of 50-50 at one point. And the idea of electoral college, it's all tyranny of the minority. Gerrymandering is all tyranny of the minority. And now they have this court and they would never go along with this. It's going to take Democrats to get 60 Senate seats, which seems like it's impossible. But don't forget, Obama actually had it for 2009 and 10 for not the entire time because Franken won his election later into the cycle. But still, it would take 60 seats because unless Democrats did the right thing, got rid of the filibuster, I think this is a great idea. I sincerely believe it. And Elie, one other thing, what do you think Alito's thinking? Like, he's like, I overturned Roe v. Wade and I got one fishing trip in 2008. You're telling me, Thomas, they bought a house for his mom? Like, your billionaire is so much better than my billionaire. I want to go talk to my billionaire. I need more.
One fishing trip that we know of. Right. And I think that's one of the huge thing, one of the other big reforms that I talk about a lot, that we've talked about together, Dean, is the desperate need for ethics reform. These people have to be brought to heel. At the very least, they have to be forced to recuse themselves from cases where their buddies have paid them before they hear the case. And frankly, there needs to be some mechanism of punishment for when they violate. So not only do we need ethics rules, we need some method of punishment for when they violate ethics rules. One of the, I think, most disgusting stories about Brett Kavanaugh, amongst his many disgusting stories, is that when he was elevated to the Supreme Court, there were 83 ethics complaints outstanding against him from when he was on the DC Circuit Court of Appeals. We don't know what those ethics complaints contained. We don't know how credible those complaints were. What we know is that all 83 of them were thrown out once he was elevated to the Supreme Court, because a lower court judge, Timothy Timjakovich, who is the Chief Justice of the 10th Circuit, or was, who was kind of handling these petitions, said legally correctly that there's nothing that he, a district court judge, could do to punish a sitting Supreme Court justice. So that these 83 ethics complaints were moot, because there's nothing you can do once the man gets onto the Supreme Court. That has to change. Yeah. that just can't be allowed to continue. And the only way that that's going to change is Congress passes statutory ethics laws that impose punishments on the Supreme Court, and then the president uses the power of the sword to enforce them against these 9 unelected, unaccountable law wizards when they run afoul of those new ethics rules. That just has to happen in a functional democracy.
I agree. And I've had, in the last, month, 2 senators from the Judiciary Committee. I had Sheldon Whitehouse on. Sheldon Whitehouse, the frustration was palpable with him about, we can't do anything. He goes, at the time, Senator Feinstein wasn't there, so they didn't have a majority functioning to subpoena anyone. But he's been for years talking about dark money and what's going on. Then we had Senator Dick Durbin on, the chair, a couple of weeks ago. And he said, well, nothing's off the table. Cause I'm like, let me ask something all my listeners ask. Why don't you just subpoena Clarence Thomas? And he went through the one time in history that tried to happen during the McCarthy era. And I knew about that. I'm like, okay. What? So Democrats.
Did you ask Dick what it's going to take? Because every time I hear him, he's just like, oh, we're not there yet. We're not. That's his catchphrase, right? We're not there yet. When are we going to get there?
Well, nothing's off the table, though, Elie. He added, but nothing's off the table. I'm like, okay, what kind of table? Look, I was happy Dick Durbin was on, and I asked him the questions I want to ask, and he gave the answers he's going to give. There's nothing, I can't make Dick Durbin do anything he doesn't want to do. He's cut from a different cloth. The senators are, when I talk to them, they, even ones who used to be in the House, they get to the Senate, and there's something senatorial, perhaps, or I don't know what it is, and it's the 6-year thing. And they know that they have to run for every 6 years, but
It's
kind of a cool life. That's what I aspire to. Got to be honest. That's
right?
like this thing.
It's power, man. It's power, and it's power that you can keep as for pretty much the rest of your natural life. Like most of those senators intend to die in office, as we're seeing. Right, like that is their goal. Once if you're a senator and you can't be president, and almost all of them think they should be president, but if you're a senator and you can't be president, then the thing that you want to do with the rest of your life is to never lose that power. And that makes you, I think, aside from just the corrupting influence of power, it makes you start to, I believe, and grant, you will note I've never been there. But I believe that it makes you start to think that your peers are the other senators, that you are beholden to the other people in the club, as opposed to the American people who put you there, right? And I think that's where the real disconnect starts to happen, where the Senate, if you're a senator, you're going to see, if you're a Democratic senator, you're going to have to see Lindsey Graham, every Tuesday. Like he's like, Lindsey Graham's part of your life now, right? In a way that your voters just aren't. And I think that that's something it's one of the reasons why my friend from across the aisle, my friend from the great state of, miss me with that bunk, right? Miss me with the my friend stuff. They're trying to kill some of your constituents. They're trying to revoke health care from many of your constituents, probably just about half. And you're going to call him my friend. That's the kind of like brain worm that only happens when you consider yourself more a part of the club of the Senate than you are part of the club as an American citizen.
I think if you're a senator, a Democrat, and you're going to refer to a Republican as my friend, at least do air quotes so we can see it. It's like my friend, and like, oh, I get it. You're not really my friend. And, it's sort of like, look at Lindsey.
My mortal enemy across the aisle.
This guy, if it was a different time, it would be a duel. I would throw my gauntlet down and we would be doing it 10 paces in, Washington Mall or something. I'm chatting with Elie Mystal. So Elie, let's talk a little bit about the case. You wrote a really compelling article for The Nation about the 303 creative case, the web design case, ushering in a new era of Jim Crow. And I want you to, because I could not agree with you more. I tweeted that instantly. I tweeted that Thursday before that. And Fox News put me in the headline, Usher's in Jim Crow. I'm like, yeah, that was before Friday. That was before the LGBT case. That was the affirmative action case. I'm like, these guys are really anti-integration. So what was your take, please, that you share?
Yeah, so 303 creative is a really dangerous case. What the court basically said is that you can pierce what's called public accommodation laws if you have a deeply held religious belief that your speech or your creative expression is being impacted. Now, public accommodation laws are the laws that we erected to break down Jim Crow. Public accommodation laws are the reason why I can rent a hotel, or maybe even an Airbnb sometimes. Public accommodations laws are why I can go into a restaurant, right? Even in the Deep South, and they can't stop me, right? What the court said is that if the proprietor of a business says that they have a deeply held religious belief and their business is creative, they can deny you service. So in the 303 creative case, I mean, there's a whole different legal backstory about how she didn't actually have a business and whatever.
I know,
which is just, that's a whole different story. But she claimed that one day she wanted to have a business doing graphic design of wedding websites and proactively wanted to discriminate against LGBTQ couples. And the court said that that was okay because creating wedding websites is a creative speech exercise. Now, I don't agree that creating a wedding website is a creative speech exercise at all. But the real issue here is that now everybody is every bigot, every 2-bit bigot out there is going to claim their business is actually a creative enterprise or a speech act, and that allows them to discriminate against LGBTQ people. And eventually they're going to make the same argument for how that allows them to discriminate against racial minorities. The conservatives, especially the ones that try to seem like they're reasonable and liberals sometimes agree with, like the George Conways of the world, who I still do not understand why liberals listen to him at all. They've tried to soft shoe that decision by saying, oh, it's very obvious when somebody's engaged in creativity versus when it's not. Folks, it's not obvious at all, okay? It's very obvious that Dean, a radio show host, is engaging in a speech act when he hosts radio, right? You couldn't make Dean have on a guest that he doesn't want to have on because it's a speech act, right? I think that's a clear line in the sand, right? Is it as clear that, let's say, a jeweler is in a creative business or not? So what if I want to get a wedding band made and I want that, or wedding ring made, and I want the jeweler to stick a rock into a band, and the jeweler says, are you gay? And I say, why does that matter? He says, well, I only stick rocks into bands for straight people because it's actually a creative enterprise, me putting this rock into this band. I'm like, it's not creative, it's technical, it's engineering. You're like a carpenter, right? And then the carpenter comes out and says, actually, I'm creative too, because when I make my chair or my door or my, woodworking set, it's actually a very artistic enterprise. And I don't make doors for no gay people. And you're like, what are you talking about? You're a carpenter. You're like a cook. And then the cook says, actually, I'm also involved in the creative, but no soup for you, gay people, because my soups are creative. You see where it goes, right? Like at every point, there is some jobs in this country are not done by automatons, right? At every point, there is some spark, there is some measure, there is some, personal, you put your personality into your work, right? And there are lots of professions that can claim, according to the Supreme Court now, that their creativity allows them to be bigoted to people who are seeking services that are otherwise available to the public. So it's a gaping hole in public accommodation law. Don't listen to people like George Conway who want to tell you that, oh, it's actually all going to be fine because the Supreme Court can be trusted to make these decisions in the fair and right way.
I couldn't agree with you more. And, as someone who worked in a kitchen and who was a cook, my dad was my dad's diner, my family's diner. But I would think cooks like my dad, who was making soup, would say there's a creative aspect to it in all sincerity. I put a little bit more of this broth and I add some more carrots, or I do this that's different than other cooks. And you can easily see that argument being made with a straight face. And that's what's so concerning about it. And we know the bigots are going to use this. But let's get to the race part, because people are throwing around the question of race. Would it be harder, though, from a legal point of view, to find an exception based on religion for race?
Not under this ruling. That's the thing. Not under this ruling. It's not harder because while you have to say that you have a deeply held belief, they're also saying that belief is simply a speech act. And we know from the past, again, this, like the first segment, Dean, this is not stuff I'm making up. I'm just reading what segregationists have said in the past to uphold Jim Crow. And if you look at what their actual arguments were back in the 50s and 40s and 30s, it was a Christian argument that God did not want the intermingling of the races, that God had decided that it was best for Black people to eat out of the back of the kitchen while white people were right. That those were not just straight up like genetics arguments. Those were made under the color of Jesus. And so, of course, these people will find a way to say that their deeply held belief that their creativity should be limited to only the white race is somehow tied to their belief in God. That's not me making it up. It's what they've actually done before. And it's not at all clear that the Supreme Court will stop them. But Dean, even if they do, and this is a point that I feel like has gotten lost a little bit in this legal conversation, a lot of your listeners, I do not think, know what it's like to be denied services because of your race, color, creed, or sexual orientation. It is humiliating. It is humiliating to walk into a store with your friends, with your family, with your community, and just be told to get out, just be denied because of something about you that you can't change. That the Supreme Court would invite this kind of indignity, would invite this kind of bigotry, on the hope that 5 years later, 6 years later, 8 years after the actual incident, somebody is going to sue and bring it to the Supreme Court, and they will say 8 years later, actually, that bigotry was wrong. How the hell does that help? Because most people, most of the time, they're not going to make a federal case out of it. They're not going to lawyer up and call in, Larry Tribe to argue their constitutional rights. They will take that punch on the chin. It will hurt. They will go home and they will get up tomorrow and go back about the rest of their lives. They will suffer that indignity in silence most of the time. And so what the Supreme Court has really done is shift the burden of that indignity back onto the individual customers, back on to the individual vulnerable people, and say, hey, guess what? The bigots can say whatever they want to you, can deny you whatever they want to deny. And if you want to stop them, you got to pause your whole life, lawyer up, and wait 5, 6, 7 years before maybe a judge makes a ruling. That's insane to me.
It's horrific. And, Justice Sotomayor in her dissent, I read the line earlier for people so they understand the historical context of her dissent in the same-sex marriage website case. She wrote, today, the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class. She's saying, so everyone understands, for the first time in the history of this court, they're saying a business can open and say, nope, a protected class, we can say no to you. And the pain that must cause, as you're noting, and the frustration and the anger and whatever self-loathing issues for some people, I can't even fathom. I mean,
to bring it back to the law, Sotomayor says something important that I think a lot of people are missing as well, and that's what she's saying about protected class. I've gotten a lot of people, mainly online, who are just like, oh, if they can do this, well, then how I can discriminate? I'm going to open a business and not allow MAGA people to come in. Yeah, you can do that. You didn't need a Supreme Court decision for that, because being a MAGA jerk is not a protected class, right? Being a crazy white incel, not a protected class. There are very few protected classes in this country, right? And the reason why we have protected class status is to ameliorate, is to help vulnerable communities, right? And it's very complicated what makes one person a protected class and what makes another not, but it's generally, I'm saying, there are exceptions. It's generally an immutable characteristic, right? And it's generally applied to people who have been they're called in the law kind of insular communities. But what it really means is that, like, a cohesive community, right? So, Black is both immutable and cohesive. We kind of know what Black people are, and we know that people can't change their spots, right? Sexual orientation, in the legal sense, we treat it as an immutable characteristic, right? Being a Republican jerk is not immutable. You could read and not be Republican. That's possible for you, right? To not be as flip. Being overweight's not immutable, right? If you wanted to discriminate against people because they were overweight, you're a jerk, but it's not unconstitutional because being overweight isn't immutable, right? And there are what's called bona fide business reasons, bona fide business qualifications that allow for even, let's say, a greater level of discrimination. To stay on the weight thing for a second, it's not unreasonable for, let's say I was applying to a job at Victoria's Secret.
Interesting.
To be a model, right?
Oh, okay. My mind went to that immediately, of course.
Right? As one does, in the fullness of time. Right. It wouldn't be unreasonable for Victoria's Secret to be like, could you step on the scale there, sir? That wouldn't be unreasonable, right? I might disagree with it. I might say there's a market for plus size male models. I mean, we could have that argument, but fundamentally, it's not unconstitutional for Victoria's Secret to deny me the opportunity to model underwear in their name. That's not unconstitutional, right? There's only a very few things that are unconstitutional, and that's what Sotomayor is saying. From this very small pool of things that you can't discriminate against because they are immutable characteristics, because they are vulnerable communities, this is the first time the Supreme Court has said, actually go nuts, discriminate as much as you want.
It is unreal to see this happen, that this court has gone backwards in a modern era Supreme Court that's been known up until Roe v. Wade's overturned for expanding rights for people. Now we've gone backwards to Plessy versus Ferguson. We're going to a different time, like Dred Scott. You're going back in time for cases that upheld laws that ban interracial marriage, and the list goes on. And the Supreme Court moved forward. Very last thing, I just want to get you in the last minute here, your reaction to the ruling on the court. The college and universities cannot consider race. And what is the bigger picture that you take from that? Forget the law. These aren't legal decisions. I keep telling people these are political statements by a right-wing GOP court.
Speaking of unconstitutional, all right? So now what the court has said with the affirmative action decision is that considering a person's race is the one thing that is unconstitutional when considering a college application, right? It means that you can consider a person's geography, you can consider a person's wealth, you can consider whether or not the person had a daddy that went to the university, you can consider whether or not the person is good at badminton, you can consider whether or not the person is good at playing the piano, but you can't consider whether or not the person is all of those things while also being black in this country. That's the one thing you can't consider. And the court's saying is that it's unconstitutional for you to consider it, which is just, I mean, it flies in the face of actual constitutional law. The 14th Amendment was passed specifically so we could have racial ameliorative programs. The first affirmative action program was done during Reconstruction, and they ratified the 14th Amendment specifically so that law would be legal. So it's just legally false. But again, why are they doing this? They're doing this to make the world safe for a certain kind of mediocre white bigot. That's what the 303 creative case is. That's what the affirmative action case is. There are aggrieved whites with like nothing better to do than hate on gay people and racial minorities, and the Supreme Court wants to make sure that they feel okay.
It's unbelievable. And before I let you go, all in my head, and I played it for people earlier, all I can think of was George Wallace's speech in 1963 when he was being sworn in. And I played it when he talked about the cradle of the Confederacy and then infamously said, segregation now, segregation tomorrow, segregation forever. And the crowd went crazy. And while it's not exactly the same, for some reason, these bucket of cases just conjures that up to me. That pre-Civil Rights era, pre-Voting Rights Act, pre-Fair Housing Act mindset, all before 64. And that's what I really feel like this court's trying to take us to.
The hardest thing that I've had to learn, I think, as I've grown up, right? The hardest thing I've had to learn over the past, 10 years with the rise of the Tea Party and the rise of Trump is that, when I was in school, I was taught that the segregationists and the bigots were defeated. And what I've had to learn is that they weren't defeated. They just waited. They just waited for the opportunity to bring it all back around again. And now they have that opportunity and they're bringing it all back around again. And I'll just, which is I'll end where I started. I want to know when Dick Durbin will get there. When will enough be enough for the Dick Durbins of the world? Because it's certainly enough for me.
Well, everything's on the table. It's a huge table. Everything's here. We got croissants. We got little fruit. We got little tarts.
Abortions for some, tiny American flags for others. All on the
Well, Elie, and by the way, Elie's new podcast. Tell people in the last 30 seconds. Tell people where they can find the podcast.
Contempt of Court's on wherever you get your podcast. It goes through all the different court reform ideas, and we talk about the scholarship behind it, and then also the politics behind it.
Check it out. Contempt of Court. Elie Mystal. Read his stuff at The Nation. He's a great writer. Thanks so much, Elie, for being on as always. Always appreciate it, brother.